Good morning, everybody. My name's Daniel McNally. I'm a corporate defence and regulatory lawyer here at Freeths, and I'm going to talk to you this morning about the new Economic Crime and Corporate Transparency Act, and more specifically, the new Failure to Prevent Fraud offence, which came into force on the 1st of September this year. Next slide, please, Tom. So in terms of the background, what's this all about? Well, every year the cost of fraud is estimated to cost the UK economy £219 billion. With that background, the government have taken the view that it needs to be easier to hold corporate bodies to account for criminal conduct and specifically fraud. And therefore, that has eventually led to the introduction of the new Failure to Prevent Fraud offence on the 1st of September, which is section 199. Next slide, please, Tom. So in terms of how the offence is committed, so the new Failure to Prevent Fraud offence will be committed in circumstances where an associated person of an organisation commits fraud and that person is providing services for the organisation or on behalf of the organisation with the intention of benefiting the organisation. So in terms of breaking that down slightly, first of all, there needs to be a fraud offence. Fraud in itself is quite a wide definition within the legislation. Secondly, there needs to be an associated person. An associated person, by definition, is an employee, agent, subsidiary, or other person who's undertaking services on behalf of the organisation. And then lastly, there needs to be an intention to benefit the organisation itself. That doesn't mean necessarily that the organisation has to benefit, but the intent has to be there. Next slide, please, Tom. It's worth adding as well that the new offence does have extraterritorial reach. So, but there has to be a UK nexus. So in simple terms, either the fraud offence itself has to be committed in the UK, either in its entirety or part, or the benefit or loss caused by the offence has to occur in the UK. So if you tick one or more of those boxes, then there is criminal liability in this country. If you don't, then there isn't. Next slide, please, Tom. Who does it apply to? Well, this is significant because it only applies to large organisations only. And large organisations are defined as those who meet two or more of the following criteria. So firstly, they have an annual turnover in excess of 36 million. Secondly, the balance sheet value exceeds 80 million. And thirdly, they have more than 250 employees. It's important to note that when you are criteria, you assess it based on the previous financial year's figures. So, for instance, if a fraud offence is committed today, then when applying this criteria, you would look at the previous financial year rather than the current financial year. The other thing to note here is that the criteria itself applies to the whole organisation. So, for instance, if you have a group structure, then it would apply not only to the parent company, but to all of its subsidiaries as well. So that's an important point to bear in mind as a means of highlighting the reach of this legislation. So, for instance, if you had a parent company and 4 subsidiaries, if the parent company didn't meet the criteria, but as a group it did, and fraud was committed for the benefit of the parent company, then the parent company would be liable under this legislation. Similarly, if you had a subsidiary within that group which didn't meet the criteria, but as part of a group it did, then again, if fraud is committed for the benefit of the subsidiary, then the subsidiary would be criminally liable. So it's an important point to bear in mind. You have to meet the large organisation criteria. Next slide, please, Tom. That being so, how do organisations avoid criminal liability under this new legislation, and specifically under section 199? Well, they avoid criminal liability by putting in place reasonable fraud prevention procedures. Now, that in itself is not defined in law, but there is guidance out there which is based on the 6 principles, which I'm going to cover now. So, in essence, if you follow the guidance and if you adhere to the 6 principles, then even if fraud occurs within your organization, providing that you can demonstrate that you have followed the 6 principles, then you have a statutory defence to any allegation that you failed to prevent fraud, and therefore, if you successfully raise that defence, you avoid any criminal liability. So what are these 6 principles? Next slide, please, Tom. Firstly, there needs to be evidence of top-level commitment to tackle this issue. That could be evidenced, for example, in the form of an anti-fraud policy, setting out the company's position, along with potential consequences for breaching that policy. Top-level commitment as a means of highlighting that should also be sufficient resources made available to tackle this issue. So, for instance, have the board allocated a specific person within the company to undertake a risk assessment and put in place sufficient procedures. If so, again, that's evidence of top-level commitment. Next slide, please, Tom. I touched on risk assessment. This is, in my view, the most fundamental aspect of this because everything flows from a risk assessment. As an organisation, you must undertake a risk assessment and you should record it as well. So the important point to bear in mind here is the authorities acknowledge that it's not possible to identify all risks relating to fraud, but they do expect you to undertake a thorough assessment. And when you are doing that, what you should look at, I would suggest, is who are the associated persons who are providing services for the organisation, and then consider the opportunities or the potential motivation for those individuals to commit fraud. As I say, it's important that the risk assessment itself is documented, but keep it simple. So, for instance, consider the risk, make a note of the risk, make a note of any existing control measures, and then ask yourself the question, do we need to impose or introduce rather any other control measures which are reasonable and proportionate to the level of risk? So, for instance, if you've identified something as being a low risk, then there isn't an expectation or a requirement that you will spend a disproportionate amount of money putting in place a control procedure that's not appropriate or reasonable in those particular circumstances. So again, that's an important point to bear in mind when you are undertaking that particular task. Next slide, please, Tom. And flowing on from the risk assessment, of course, you need to act upon it and introduce proportionate prevention procedures. But as I say, they have to be proportionate to the level of risk. What the government guidance also says is that organisations may wish to think about testing how robust those procedures are. So that's something which, as I say, companies are encouraged to do as part of an ongoing review. Next slide, please, Tom. Due diligence, again, this is important as well as one of these 6 principles. There's an expectation that organisations must undertake a reasonable level of due diligence on all associated persons who are acting on their behalf. So, for instance, undertaking vetting where appropriate, carrying out internet searches, using third-party risk management tools, and of course, keeping a record of that as well. As part of that, think about reviewing existing contracts if you are using third-party agents to make sure there are appropriate clauses in there which make it abundantly clear that fraud is not tolerated and that there is a power to terminate the contract in the event of a breach. Next slide, please, Tom. Communication, of course, there's no point having a fraud prevention policy and procedures if those policies and procedures are not going to be communicated to staff. So think about how you're going to embed that policy and procedure within your organization so it's understood. If you are providing training to employees and to other associated persons, then make sure you keep a record of that training. Who was present? When did that training take place? What did it cover? Consider whistleblowing procedures as well. Whistleblowing procedures are considered to be one of the most effective ways of uncovering criminal conduct of this nature. So think about creating a culture where staff feel able to raise concerns. Think about procedures that enable staff to report their concerns easily. Think about steps that you need to take to ensure that staff don't feel victimised or targeted for raising such concerns. And think about putting in place procedures so that if concerns are raised, they are investigated in a timely manner. Next slide, please, Tom. And the final principle that I'm going to talk about or touch upon is the need to monitor and review procedures. So this would include periodical reviews of existing policies and procedures, as well as responding to any new government or sector-based guidance. Have you considered that? Have you updated your policies and procedures accordingly? Furthermore, if there have been previous allegations of fraud which have been investigated, were there any lessons to be learned from that to help improve your policies and procedures? And if so, have they been acted upon? So in essence, you're looking at two things here. Is what you have in place effective to both detect fraud, and secondly, what arrangements do you have in place to investigate that fraud, and are they fit for purpose? So what factors would trigger an investigation? Secondly, who would authorize that? Thirdly, who would undertake the investigation itself? Is that an internal investigation, or is that going to be undertaken by an external third party, such as your lawyers? And I'll come back to that point in a second. How are those results recorded, and who are told about them? And then finally, how do you learn from those? You need to think very carefully about your internal investigation. The reason I say that is you need to ensure that, or you should ensure that any internal investigation report is cloaked with legal privilege. Why is that important? Well, it's important because if fraud does occur and a regulatory body takes an investigation, then the first thing they will ask for is a copy of your internal investigation report. And that may well be prepared in circumstances where you don't anticipate or intend to share that report. Clearly, if that report contains things which are not helpful, for example, if it acknowledges that certain policies and procedures weren't in place or weren't robust enough, then that's going to cause you a big problem if you are then going to try and raise the statutory defence that you had reasonable fraud prevention procedures in place. Next slide, please, Tom. What the consequences? So if those organisations who are investigated and prosecuted, if they are convicted, then they do face the prospect of an unlimited fine. In terms of how the courts would approach that, well, these fines are not intended to be a mathematical equation. That's the first point to note here. But they will look at three factors. So they'll look at the culpability of the organisation itself. So, when we talk about culpability, did the organisation have any fraud prevention procedures in place or not? If they did, but they weren't robust enough, well, that's very different to having no procedures in place at all. Secondly, they'll look at the level of harm caused by the offence. So they'll look at the value and the loss caused to victims. And one of the key points to bear in mind here is that any court will look to remove any financial benefit that an organisation has gained through the fraudulent conduct. And then finally, courts would also look at the turnover of the organisation. That's relevant because the whole point of imposing a fine is to ensure that it has a real economic impact on the organisation itself. So, if you're a company who's turning over £100 million, there is little point in imposing £1,000 fine because it's not going to bite. You're not going to feel the effect of that. So again, it all comes back to this point of proportionality. Next slide, please, Tom. And then finally, I just want to touch upon section 196. So I've covered failure to prevent fraud, which is section 199, but don't overlook section 196, which has also been introduced by this legislation. So in essence, what section 196 does is to extend corporate criminal liability for other economic crimes. Now, I'm not going to run through all of the economic crimes. They're set out in Schedule 12 of the Act itself. But in essence, in terms of how organisations will be caught by this, if a senior manager of a company who is acting within the scope of their role commits one of these economic crimes, then the organisation itself is also guilty of the offence. So again, this is all intended to make it easier for regulatory bodies to be able to hold companies to account in the criminal courts. In terms of what we mean when we talk about senior managers, so senior managers are defined as individuals who play a significant role in making decisions about how the company's activities are carried out, or how they are to be managed or organised, or they are involved in the actual managing or organising of those activities. So that is the definition of a senior manager under section 196. But important to bear in mind there as well, just as a final note, that the 6 principles I talked about earlier don't apply to this particular section. They apply to 199 only. Next slide, please, Tom. And so that's it for this morning's presentation. 15 slides in about 15 minutes, there or thereabouts. If you do have any questions, as Tom mentioned, please send those in and I'll respond to you very shortly. But other than that, thank you very much for joining this morning. I hope it's been helpful. And as I say, if you do have any questions, please don't hesitate to reach out.